Simpson, having business before the court drawn near, the Honorable Judge J. Cedric Simpson presiding.
You may be seated.
David I. Goldstein appearing on behalf of the defendant.
All right. Go ahead, Judge.
Your Honor, there are a couple of, we did review both the assessment and the recommendation. There are a couple of minor changes. In the assessment, on the second page where it says prior substance abuse related offenses, it says none reported. He did have a prior OUIL that is referenced further down, but for some reason at that point, the report says prior.
Right. I did notice that. All right.
And then there's a large paragraph that starts out, Mr. Grabowski reports that he has been involved, et cetera. It says the client is paying $659 in child support. That is no longer true because his youngest child just turned 18, but he does pay $4,000 a month in alimony.
Okay.
And I think that was the only changes I wanted to make the court's attention.
So, sir, is there anything you or your counsel want to say?
Sorry.
Go ahead.
Did have another, that was in terms of corrections, Your Honor. Sorry.
Go ahead.
Your Honor, with regard to the recommendation, the only thing I'm going to address is the request for an additional 3 days in jail. My client understands that this is not his first alcohol-related offense within the last 7 years. He also understands that there were issues with the bond during the pendency of this action, and it looks like those were addressed. It looks like he is back on track. The report I got from Community Corrections indicated that there were no positive tests. There was one test that was about a half an hour late, but that was also negative. And I don't see there any recommendation in there that be addressed, bringing it to the court's attention. With regard to the fines and costs, with regard to the treatment, the AA, et cetera, it's not something my client wants to face, but he understands it's probably ultimately in his best interest that it be addressed now before he hits the felony stage, which would be his next offense. But he does work. In fact, he's in his work clothes because he was planning on going right from here to back to work. And I really don't see, given the situation, that the extra days is really necessary.
Sir, anything you want to say?
No, sir.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly the alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow probation's recommendation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court that I'm placing you on 24 months probation. I will order fines and cost of $1,055. We will apply the bond to that. $100 prosecution recovery cost, $100 police agency recovery cost, and $720 probation oversight fees. You have a $2,500 balance, so you should be able to cover pretty much everything with that. So we'll apply the bond to that. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete an intensive outpatient treatment program, including all recommended aftercare with status reports to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. You will continue on the sober link until proof of an IOP enrollment is provided to probation. With reference to the jail time, I do believe that given the circumstances in this case and the fact that it is the second, that it is appropriate to impose the additional jail time. I'll order 365 days in jail. I'll give you credit for the 2 days that you served. Did he bond out immediately?
Well, yes, sir. I think the 2 days were when he had the violation.
I'll give you credit for the 2 days that you served. Then hold it. You were arrested that night though, right?
Yes, Your Honor.
I don't. When I sent you in, you served 2 days. Is that right?
Right. Actually, I served that day and then the next.
Right. And then on the date of the offense, you were also incarcerated.
Correct.
Okay, that's what I thought. So that should actually be credit for 3 days served. Defendant to serve an additional 2 days. Then the balance is suspended.
Can he do that on a weekend since he does work
It is the weekend.
today?
Every day with me is a weekend. Come on, Golson. Everybody works. I don't like doing that, but I think in this instance, I'll do that. Do you?
That's what he's addressing right now.
When I would like that to do both.
Just report to the Washington County Jail, 8 a.m. What is Saturday?
The 25th.
8 a.m. May 25th, 2024.
Normally you send you right now.
Oh, okay.
Okay. This way at least you can finish.
Does he want to go right now?
No, sir, I do not. No.
You sure?
Yes, sir.
I mean, I can make that happen
Yes,
too.
sir.
Mr. Allen needs something to do.
He knows you can do that because you did it once before.
You've already done that.
Yeah, okay. So we understand each other. Saturday morning, 8 a.m.
Thank you.
Your name, sir?
Cody Lee Jolly.
All right. And we have your competency report back. Have you had an opportunity to review that, sir?
I have.
Pardon?
I have.
All right. Is there any other additional evidence you want to give the court?
Not at this time.
None from the people, Your Honor. We would stipulate to the report authored by Graham Parker dated May 7th, 2024, and ask that the court make its finding based on the.
Based upon a review of that report and the only evidence before the court would find that the defendant is competent to stand trial. And that defendant understands the nature and the objects of the proceedings against him and can rationally assist in his defense. And so the defendant is deemed competent. I'd ask the people to prepare an order if you could.
Yes, sir.
In this instance. All right. Mr. Jolly, do you still wish to continue to represent yourself, sir, or do you wish to have the assistance of an attorney?
Continue to represent myself, please.
All right. I'm going to advise you of a couple of things. There's a danger in representing yourself. You understand that?
I am aware of that.
You understand that in any proceeding, the court is going to treat you the same as any attorney and that you have to abide by the court rules.
Correct.
That you will not get any favoritism from the court regarding anything or anything in the proceeding. You understand that?
I do understand.
You understand also that if at any time you make a decision that you wish to be represented by counsel, that you would have to let the court know, and the court would make sure that counsel would be afforded to you.
Okay.
You understand that?
I do understand.
All right. And so I do also have to advise you that you are before the court on 2 charges. It's 2 charges. 2 charges of criminal sexual conduct in the 4th degree. You understand that, sir?
I do understand.
And that these are alleged to have occurred on January 27, 2024. You understand that?
I do understand.
And the court also does have to advise you that these are high court misdemeanors. They are punishable by up to 2 years incarceration and or $500 fine plus court costs, mandatory HIV and STD testing, and DNA would be taken upon your arrest and should have been taken. You understand that, sir?
I do understand.
All right. So, sir, I will formally ask you, do you still wish to proceed without counsel?
Yes, I do.
All right. What do you wish the court to now set this for, sir?
The last that I was aware of was the preliminary exam that we were doing. I'm trying to move forward as quick as possible, so I'd ask you if that's where we start, that's okay. If we move
You
forward,
wish to set for a preliminary examination?
if that's the furthest along I can get, then yes.
Well, that's the next step.
Okay, then yes. That's
All right. So you want to have a preliminary examination in this matter, or you want to proceed to circuit court? There are a number of options that you would have.
okay. Yeah, I mean, if we can proceed right to the circuit court, that would be.
Okay, all right. But you understand that there would not be a hearing, the preliminary examination, which the court would attempt to make a finding or would make a finding as to whether or not crimes were committed and you committed them. That if you were to proceed directly to circuit court, that hearing would not take place. You understand that?
Trial. Yes, I understand.
Mr. Jolly.
Yes, I do
Mr.
understand.
Jolly. Mr. Jolly.
Yes, sir.
You've been before me, I don't know how many times, right? Are you sure you don't want somebody to just help you make these decisions and to assist you as an attorney in this case?
Again, I choose to represent myself. I was aware of the help and was thankful for the help the other day. If you know, if you recommend that I talk with somebody as I leave here.
Well, I'm not going to recommend you do anything. I'm a little bit concerned because when I ask you questions, I don't think you know what you're doing. I don't think you know what you're doing procedurally. And that causes me a bit of a concern. You want to get to, as I told you the last time you were here, you want to get to a certain point. You're not sure how to
go back to the
there.
preliminary exam. We can
You want a preliminary examination?
That'll work. Yep. Yes, I will.
All right. If you want a preliminary examination, you intend to represent yourself. Is that correct, sir?
Correct.
Do you have all of the discovery, sir?
I filed for it. I'm gonna have to refile now that I'm competent, but I don't, not when I'm in my possession because I was incarcerated.
All the discovery has not been provided. You don't have it.
It was emailed to me, but I'm incarcerated now, so I don't have it now. Request.
If the people could try to make sure that whatever discovery is, it be provided to the jail so that they can get it to this defendant.
I can print another copy of the report.
Okay.
Not today, the printer in our office is broken, but there was a media notice that was body cam that was given to him in court at one of the last dates.
Okay.
That was on a DVD.
You remember that, sir?
I do remember the disc. Yeah, I didn't. Yeah.
Okay.
So he has the disc.
He has the disc. He just
another copy of
the paper report, and we'll get that to you. Okay. Would the people have their witnesses available the 4th, or you need more time? All right. Preliminary examination in person will be set June 11th, 2024, 9 a.m. That's before me. And we'll continue this case. All right. Thank you, Mr. Jolly.